please, your lordship, my lord. Seeking your lordship indulgence, my lord. Item 24, I beg to mention. My lord, in this case, my lord, my learned friend who is dealing with the case, junior friend, is indisposed. So I have got the consent of other side. May kindly be passed over for the day, my lord.
On the request of Mr. M.H. Raj Baldwin, learned counsel for the petitioner may be the consent of the other side. Admission hearing of this matter stands passed over for the day.
Obliged. May it please, your lordship.
My lord, petitioners before your lordship were evicted from their patta land. And what happened, my lord? They cultivated some jute cultivation.
What do you want?
My lord, my prayer before your lordship is this: tomorrow case may be listed because there is some urgency.
What is the urgency?
Urgency is this, my lord. We raised jute cultivation. Now it is the time of harvesting, my lord. Our dwelling houses has been demolished. Now, my lord, the jute is going to be dried up. It may be
All right, Friday. One day, nothing will happen. Friday.
Yes.
May I please, your lordship. So I'm paying for listing of the matter, lordship.
What listing? Listing for what?
Lordship for admission, lordship.
You have to first go to the registry.
Lordship, it will consider.
First go to the registry, then you tell them to list it, they will do it.
I'll file application, lordship. All right.
May I please, your lordship? Lordship, item number 48. Lordship, with the it is a joint prayer by all the parties. The pleadings are complete. It may come up for hearing on a hearing day. I am led by learned senior counsel K.N. Chaudhary.
On the joint prayer made by Mr. G. Khandelia, learned counsel for the applicant stroke respondent, as well as Miss
J. Chopra.
J. Chopra, and as well as Mr. J. Chopra, learned counsel appearing for the opposite party, who have submitted that this matter is ready as regards pleadings and can be taken up for disposal at the stage of admission hearing, comma, the registry to list this case on 25th of September. as
May I
a-
pray for 26 because it is a Tuesday, lordship.
26th.
Much obliged.
Yes.
May I praise the lordship? Lordship, I beg to make a mention for adjournment of item
You
number.
are pleasing or praising?
Praising.
Praising. You can't praise the judge while mentioning. Be
Sorry,
clear, what are you saying?
I'm making a mention for adjournment of
Yes,
item
what
number
did you
20.
say just now?
I'm making a mention for adjournment.
No, you said, may I praise?
Please,
You
please,
can't
please,
praise.
please, Your Honor.
Yes. Yes,
I'm making a mention for adjournment of item number 28 with 29.
28 and 29.
28, 29, the learned engaged counsel is out of station. Mr. J.C. Gaur is leading the case.
28 and 29. You are for the petitioner.
I'm for the petitioner.
The prayer for adjournment has been made in these cases on behalf of the petitioner on the ground that Mr. J.C. Gort, learned counsel, is out of station. Since the prayer is not opposed, same stands allowed. Let this matter be listed again after 4 weeks. Let these matters be listed again after 4 weeks.
Highly obliged.
Yes.
Next promotion, item 1.
Yeah, please, Your Lordship. This case, Your Lordship, what has happened, Your Lordship, this is relates to land acquisition compensation, Your Lordship, issue, and this village, Your Lordship, Pudubani Nagaon, Your Lordship, they were paid, Your Lordship, compensation against the rights, Your Lordship, but no compensation against the land. Now and then, when they made inquiries in the office, they were told that in 1969 there were an acquisition proceeding for the national highway, and 15 bighas of land has been acquired. And subsequently, they came to know that although the acquisition proceeding was for 15 bighas, but in 1984 and 85, a stretch of land.
All right, we'll issue notice. Has Mr. S. Thakur, learned counsel for the petitioners. Also heard Ms. N. Bordole, learned standing counsel, Revenue and Disaster Management Department, Assam, appearing for the respondent number 2. Full stop. Ms. M. Borman, learned government advocate, Assam, has appeared for respondent numbers 3 and 4. And
6.
and Mr. D. Bora, learned standing counsel, NHI DCL, for respondent number 6. Full stop. Aggrieved by non-payment of compensation for acquiring the land allegedly belonging to the petitioners, the instant writ petition has been filed seeking a writ of mandamus. I have perused the amendments made in the writ petition. The learned departmental counsel have prayed for some time to obtain instruction. Now I am 8 weeks. Who is for respondent number 1? Any CGC here? Any? Actually, D borrow for 1 and 6, কোথায় করে দেব? So, respond number, Miss Bordone for 2 and 5. Aru N Burman from 3 and 4. Since the respondents are already represented, no formal notice is required to send. In this case, extra copy of the repetition from a requisition numbers will be furnished to the learning department.
Item 2, your lordship, similar prayer, your lordship, in respect of a different language. Same issue,
Who is for whom?
same, your lordship.
Sorry?
VLC for respondent number 6, standing council and it's a DPL.
So 1 and 6 are a VLC number. This VLC. The rest will be same, is it?
Yes.
Yes. Okay. Baki same.
Deep job.
My lord,
Yes.
I am running a restaurant by obtaining trade license, etc. And suddenly the municipal authority, some municipal persons has come and imposed a fine upon me. Page number 40, my lord. Receipt of the fine may kindly be sent.
So there was earlier some.
Yes,
Order-
earlier there is an order, but he can run a restaurant as well as the hookah bar as well as smoking. They have to be separate zone. In this particular restaurant, everything was free. On the table it was served. That's the issue, my lord.
That is-
As well as the trade license, the amount he has deposited is less than the schedule. Amount he has deposited the trade license, that amount is also less. That had to be, he had to pay more. In the year 2022, he paid 8,000 odd rupees. Subsequently, he paid 2,000 something in the next year. That amount is also less. He was
So
violating.
you are saying it was served in the designated area.
Yes, yes.
And he is saying it was served in the main
Open
restaurant.
entry.
My lord, it did it. Even that is why we have.
So,
brought
so
some
tell us
photographs also.
how does the court accept
No,
your
we have-
argument or his argument?
We have brought some photographs also. That will
So I
clarify.
understand.
That is why,
Your word against his word. What is the principle to
my lord.
arrive at
But
a
only
finding?
see what is the receipt, my lord.
You have to tell me the principle. I'm not interested in what is happening.
Yeah.
You say it was not served in the open. He says it was served in the
There
open.
is totally different.
All right, I'm issuing
area,
notice.
totally
You're not
different area.
Answering the question. Heard Mr. S.J. Sharma, Learned Counsel appearing.
I'm
for
waiting
the-
for-
S. Sharma, Learned Counsel appearing for the writ petitioner. Peruse the averments made in the writ petition. The petitioner is aggrieved by the action initiated by the GMC authorities in seeking to seal the it's
No,
a-
no,
The seal,
my lord,
they
It will not be
have
sealed. It is running. Presently, it is running. Presently.
The restaurant is running, but they are not allowing to run me properly. Your my
they
my
are not
lord,
allowing what?
my lord, kindly see what is the fine, 1,50,000, and that too on what count? My lord, running business with invalid trade license, running hookah without trade license. They have no provision of trade license for hookah.
So in your synopsis, you said they are compelling the petitioners for immediate payment of fine,
But
threatening to seal,
That,
close down their restaurant.
yes, they have,
Then when I dictated in the order, you say no.
no, they have threatened us to seal.
Hmm.
Either pay rupees 1,50,000 immediately without any hearing, without any show cause, just pay rupees 1,50,000. That is too much.
Where is it? Where is
no,
it?
it has been paid, my lord. Page number 40.
Having no alternative, we have paid them the check amount. Now also they are regularly cheating us.
Hmm.
They are regularly cheating us.
So this 1,40,000 or
1,50,000.
50,000, this was determined by which procedure?
No, because there is the amendment in the act, my lord. That's why that the fine has been imposed, my lord. If lordship ultimately he succeeds, that will be returned, my lord. His prayer is that it will be returned with interest. That can be done, my lord. But
That is no argument. If he fails, then he will pay
No,
the amount.
that's-
Same argument. So that
the
is
same
neither
time-
here nor there.
I will come with the affidavit, my lord, and detail affidavit,
Hmm.
how it has been done, my lord. Because
So in the meantime,
in the meantime, he's running. No, we will not disturb him.
They are regular district,
All-
regular persons are coming. my lord. So in
I
the
have-
meantime, we shall
no
not disturb.
further measures till the next stage.
But if he runs as per law, if he runs as per law, no prosecution will be taken, my lord.
that order may be passed.
All right, you take down so and so, assailing the demand raised on 36/2023 by the GMC authorities, imposing an amount of rupees 1,50,000 as license fee for running the food joint,
Good judge. It will-
uh, by the petitioners. The instant writ petition has been filed. Mr. Sharma submits that his clients are operating the restaurant by complying with all requirements of law, and cigarettes stroke hookahs are allowed to be consumed only in the designated area. Notwithstanding the same, a heavy penalty has been imposed on the petitioners, and the respondents are threatening to close down the restaurant if the amount is not paid. Full stop. Mr. Bora Lanet SC GMC, on the other hand, submits that if the petitioners operate the restaurant in compliance with the rules and regulations laid down by the GMC, there would be no occasion to interfere with the operation of the restaurant. However, according to the GMC authorities, the petitioners are allowing cigarette stroke hookah to be consumed openly within the restaurant premises. Hence the impugned action. Full stop. After hearing the submissions made by learned counsel for the parties, this court is of the opinion that in the absence of an affidavit filed by the GMC authorities, it will not be possible to address the controversy raised in this proceeding. Mr. Bora prays for 4 weeks time to file affidavit, bringing the stand of the GMC authorities on record. Full stop. In view of the above, issue notice of motion returnable in 4 weeks. Since
I'm appealing for all the rest.
Mr. Bora, S. Bora, SC GMC has appeared and accepted notice for all the respondents. No formal notice is required to be sent in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the learned departmental council within 3 days from today. Heard on the prayer of interim relief, having regard to the overall facts and circumstances of the case, it is hereby provided that no coercive action pursuant to the demand raised on 36/2023 upon the writ petitioners shall be initiated, subject to the condition that the petitioners operate the restaurant by complying with all the requisite rules and regulations.
Problem.
May I please? We have challenged the clause 7 and 8 of the notification, that is lordship will find at page 27.
What is your prayer here?
Yes. Prayer lordship will find at page, page 22.
Clause 7 and 8 of notification dated 18/10/2012.
Well.
So we'll issue notice at this stage. But Mr. M. Mondal and counsel for the writ petitioner peruse the amendments made in the petition. The petitioner is entirely seeking a direction for payment of victim compensation of a sum of rupees 5 lakhs due to the death of her son. Full stop. Ms. N. Bordelais, non-standing counsel, Revenue Department, Assam, has prayed for some time to obtain instruction. NOM 6 weeks since Ms. Bordelais has appeared and accepted notice for respondent number 1.
4, Your Lordship.
For respondent number?
4.
Who's for 1? Union of India you are representing, is it?
1 will be CGC, Your Lordship.
So give me a name of a CGC who, since Ms. B. Sharma Lani CGC has accepted notice on behalf of respondent number 1. Ms. M. Burman, Learned Government Advocate Assam for respondent number 2. Mr. P Nayak, Lanet SC, Finance Department, Assam, for respondent numbers 6. Assam State Legal Service Authority.
No, it's not. 5, sir.
3 and 5. Miss N. Bordole, Planet SC Revenue, for respondent number 4. And who's the standing counsel? Miss Raki
Yes,
Chaudhary
yes,
is the-
yes.
and Miss R.S. Chaudhary, Lanet Standing Counsel, Asalsa, for respondent number 6, 7, and 8. Service of notice is deemed to be complete in this case. Extra copy of the writ petition be furnished to the learned department council within a week from today, so as to enable them to obtain instruction. Let this matter be listed again by reflecting the name of learned counsel for all the respondents in the project. Please inform Ms. Chaudhary.
Pleasure.
May I please, your lordship,
Yes.
matter kindly pass over for the time
Durga
being.
Puja village, what do you want?
The Angus council is busy in another court.
Oh, who is the engaged counsel?
Yes, sir.
First of all,
RK Deka.
May I please, Your Lordship. My lord, this petition is directed against annexure 2 and 4 documents, my lord. Annexure 2, your lordship will find at page number 25. My lord. This is with regard to my lord notice served upon the petitioner by her husband, my lord.
you are assailing the Talaknama dated 31/2022. Notice has to go. But Mr.
A. Ali.
A. Ali, learned counsel appearing for the writ petitioner, assailing, inter alia assailing the Talaknama dated 31/2022. The instant writ petition has been filed inter alia contending that the impugned Talaknama has been issued, has been executed on extraneous consideration and without following the due process prescribed by law. Full stop. Ms. M. Borman, learned government advocate, Assam, prays for some time to obtain instruction. NOM 8 weeks since Ms. N. Bordole, learned SC Revenue, has appeared and accepted notice for respondent number 1. Ms. M. Borman, learned government advocate, Assam, for respondent numbers 2 to 4. No formal notice is required to be sent to the said respondents. Extra copy of the writ petition be furnished to the learned department council within a week from today, so as to enable them to obtain instruction, file affidavit. Petitioner to take steps for service of notice upon respondent number 5 by registered post with AD within a week from today.
Obliged.
Item 7.
May it please your lordships. Petitioners had submitted several representation before the circle officer for demarcation of land part entries.
Demarcation of land, why don't you find out what has happened? This is a notified matter. Let it be next week. Mr. S. Hawk, learned counsel for the petitioners is present and submits that their application seeking demarcation of the land has not yet been acted upon by the circle officer of Kamalpur Revenue Circle. Full stop. Ms. G. Hazarika, learned SC Revenue Department, Assam, submits that demarcation of land is a within course notified subject, and therefore she be granted a week's time to obtain preliminary instruction from the concerned circle officer addressing the grievance raised in the writ petition. Prayer allowed. Registry to list this matter for motion again after a week. In the meantime, 2 extra copies of the writ petition be furnished to Ms. Hazarika and Ms. Borman, so as to 1 extra copy each of the writ petition be furnished to Ms. Hazarika and Ms. M. Borman, learned G. Assam, so as to enable them to obtain instruction.
Obliged.
Item 8.
May I please, order. We have challenged the blood impugned order that your lordship will find at page 49.
Yes.
Yes, my lord, against this, my lord, appeal is live. And accordingly, my lord, he has filed an appeal that your lordship will find at page 27. Sorry, my lord, page 50, my lord,
Hmm,
page 50.
yes.
Yes. That appeal is pending, my lord. No response is given, my lord.
Let the appeal be disposed of within 60 days. All right, take down heart, Mr. M. Mondal and counsel appearing for the petitioner. Agreed by the order dated 1/9/2022, issued by the executive officer, Vilasipuram Municipal Board. That is the respondent number 7 hearing, whereby the building of the petitioner was sealed under section 32 of the Assam Building Rules, 2014, for carrying out the construction without obtaining prior permission from the municipal board. The petitioner had preferred a statutory appeal before the Commissioner and Secretary, Government of Assam, Department of Housing and Urban Affairs, Dispur, on 27/2/2023. However, since no action has been taken on the appeal referred by the petitioner before the appellate authority, the instant writ petition has been filed. Mr. Mondal submits that the impugned order has been issued in an arbitrary and illegal manner, and therefore the appeal preferred by the petitioner deserves expeditious hearing. Ms. M. Burman, learned government advocate Assam, appearing for the official respondents, submits that if the appeal is pending before the appellate authority, namely a commissioner and secretary, you have not made him a party here.
Yes, my lord. Urban party, my lord.
Huh?
Party, my lord. Respondent number 2, my lord.
Respondent number 2 is secretary. They
Yes, my lord.
preferred the appeal before commissioner.
But nowadays, my lord, commissioner is replaced by secretary, my lord.
Respondent number 2. This court may pass an order directing the appellate authority to dispose of the appeal in a time-bound manner. Mr. Mondal has also agreed to such a recourse. In view of the above, without expressing any opinion on the merit of the claim projected by the petitioner in this proceeding, this writ petition stands disposed of by providing that the respondent number 2 may give a personal hearing to the petitioner and thereafter pass an order disposing of the appeal on merit as expeditiously as possible, preferably within a period of 60 days from the date of receipt of a certified copy of this order. Writ petition stands closed. Yes.
Can it be, my lord, 45 days, my lord?
No.
Now, my lord, here also, my lord, the impugned order that your lordship will find at page, my lord, 58. And 57 and 58, my lord. Now, under clause 29, appeal lie, my lord. He has filed an appeal before the, my lord, deputy commissioner. That appeal is not, my lord, attended.
You are aggrieved by the order of 19/4/2023.
Yes, page 57 and 58.
Now, this will have to issue notice.
Yes.
What is your basic relief?
My lord, basic relief, my lord, to, my lord, appoint, my lord, agents, new dealership, my lord, in favor of the petitioner.
New dealership?
New dealership in favor of the petitioner, my lord, of PDS items, my lord.
Mr. M. Mondal and a counsel appearing for the petitioner. The petitioner is basically aggrieved due to inaction on the part of the respondent authorities in their failure to consider his request for appointment of new licensed dealership public agent of PDS articles under his fair price shop,
Yes, fair price shop.
coming within the domain of his fair price shop. I have perused the affirmance made in the writ petition. Ms. M. Burman, learned government advocate Assam, raised for and is granted time to obtain instruction in the matter. NOM 8 weeks or 6 weeks. Since Ms. Burman, learned government advocate Assam, has appeared and accepted notice for respondent numbers 1 to 7, no formal notice is required to be sent to the said respondent. Extra copy of the writ petition, requisite in numbers be furnished to the learned government advocate Assam so as to enable her to obtain instruction. Petitioner to take steps for service of notice upon respondent numbers 8 and 9 by registered post to PD within a week from today. Yes.
Obliged.
Name, please, your lordship. Your lordship. Madam,
What is the impugn order 10/4/2018?
yes, lordship. Thereafter, lordship,
You prefer an appeal under the land revenue regulation?
yes,
appeal lies-
lordship, in the meantime, we have preferred an application before the district commissioner.
Hmm.
So my prayer at this stage to dispose of that application.
No, an appeal lies against this order. Why have you filed application?
Yes, sir.
There is a
It's
provision.
been
in
filed.
the- Huh?
Yes.
Please listen to the query. The order of the additional deputy commissioner dated 10/4/2018. It is appealable order,
Yes.
right? Have you preferred an appeal?
We have preferred application before the district
So
commissioner.
that means you have not preferred an appeal.
Yes,
You
Lord.
prefer an appeal. Withdraw it and prefer an appeal. Application and appeal are two different things. In matters where a statutory appeal lies, you can't substitute it with a representation.
Lordship, may I dispose of my application, observing that lordship,
Huh?
instead of withdrawal lordship.
There is a limitation of appeal, lordship.
Hmm.
That is fine.
No appeal
That
under.
is the reason they filed application.
Lordship.
Hmm. What is the provision 147?
147
lordship.
before the revenue board.
And limitation of appeal is lordship. After the after the expiration of the 2 months from the date of the order appeal.
But then the delay can be condoned,
Yes, lordship.
is it not? Sorry? Yes,
Along
let
with
us
the
prefer an appeal
Yes, lordship.
before the authority full stop. You take down heard Ms. T. Shomlari, counsel appearing for the writ petitioner. Also heard Ms. G. Hazarika, learned SC, Revenue Department, Assam, appearing for the respondent number
One lordship.
1 and Ms. M. Burman, learned Government Advocate, Assam, appearing for the respondent numbers 2 and 3. Full stop. Being internally agreed by the order dated 10/4/2018, passed by the additional deputy commissioner bracket revenue bracket Tinsukia, the instant writ petition has been filed. Inter alia contending that file contending that the impugned order is illegal. Full stop. However, I find that the order dated 10/4/2018 is appealable under Rule 147 of the Assam Land and Revenue Regulation. Full stop. Ms. Som has also agreed that the order is appealable, but she submits that the appeal will be barred under the period of limitation. Barred by limitation, full stop. To that, Ms. Hazarika and Ms. Burman submits that an appeal can be preferred even now with an application seeking condonation of delay. If that be so, and since there is no dispute about the fact that the impugned order is appealable in nature, hence I dispose of the writ petition at this stage of motion hearing by granting liberty to the petitioners to prefer an appeal before the appellate authority under Rule 147 of the Land and Revenue Regulation, along with an application for condonation of delay in filing the appeal. Full stop. If such an application is filed by the petitioner accompanying the appeal, the same be considered on its own merit and disposed of by a reasoned order.
I'm deeply
The petition
obliged.
stands closed. Yes.
Wait, Your Lordship. Lord, an expression of interest, Your Lordship may see page 66.
It's a tender matter.
Matter.
You have to wait till Friday. This
that
bench
will-
is not taking up tender matters.
Below the tomorrow is this will last.
Act two, list it before the appropriate bench. This is a bench four matter. They are not your fault. But
At 2 o'clock, madam.
Huh?
At 2 o'clock.
at 2 o'clock. It appears that this is a tender matter and pertains to civil bench four. However, the writ petition has been wrongly listed before this court today. In view of the urgency expressed in the matter by Dr. A.K. Saraf, learned senior counsel for the petitioner, registered to list this case before the appropriate bench at 2 p.m. today. A order to liable sign code, you send it to them.
I'm against,
With the approval of the Honorable Chief Justice.
I'm against the inaction of the authorities to act under regulation 24 of the land and revenue regulations. At this stage, I'm praying for a notice, Your Lordship. I have also submitted representation unless Your Lordship will, my instruction is that we'll also be happy if a direction is issued to dispose of the representation within a.
What is the representation?
That to act in terms of the mandate of regulation 24. To demarcate the land.
Which page is the representation?
65.
Page 65.
To get the land, to get the land. The word is to get the
Never
land.
forget
My- oh, come
the
on.
word used.
But whether that question is that,
What
whether
are,
position is that.
what are the words your officials are using?
My lord, will
Don't get it
disposal
wrong.
of representation in accordance with rule, my lord, is nothing. Lord,
In
it's
accordance
to
with regulation 24,
Hello.
that will do.
All right, take down her, Mr. Aichodhry, learned senior counsel, assisted by Mr. S. Vishwakarma, learned counsel appearing for the writ petitioners. Also heard Mr.
225.
Hmm?
Private respondents are there.
Oh, private respondents are there. We have to
They are
issue-
pro forma, my lord. Because otherwise, my lord, separate pattas have been issued. There is
Disputes are between them, my lord. Disputes are
So
between them,
the authorities will.
my
take
lord,
a
after
decision.
hearing both the sides, my lord.
there are separate pattas issued.
Also heard Ms. G. Hazarika, learned standing counsel, Revenue Department, Assam, appearing for respond number 2, respond number 1. Mr. J. Chutia, learned SC KSC for respond numbers
225.
2 to 5. The petitioners herein claim to be the owners of land measuring 24 bighas, 4 kathas, 16 leches, covered by DAG number 51/296 of periodic patta number 95, situated at village number 1, Tarabasa, under Khuloni Moja. Full stop. The petitioners had submitted representations, stroke applications before the revenue authorities for demarcation of their private patta land. However, apparently due to a dispute between the petitioners and the private respondents hearing, no action has been taken on their request for demarcation till today. Full stop. Mr. Chaudhary submits that the application made by the petitioners is liable to be considered as per Rule 24 of the Assam.
Land and revenue regulation.
Is it rule or section?
Regulation.
Under Rule 24 of the Land and Revenue Regulation 1886, and therefore there is no justification for the respondents to sit over the application submitted by the petitioners. Full stop. In support of his above argument, Mr. Chaudhary has invited the attention of this court to the representation dated 13/6/2023, submitted by the petitioners before the Joint Secretary from our Department of Revenue, KASC, with by renewing their prayer for demarcation of land. Full stop. Mr. Chutia, learned standing counsel KAC, on the other hand, submits that there is a dispute between private individuals over a part of the land, which is delaying the matter. Full stop. Moreover, in the garb of the process of demarcation, the petitioners are making an attempt to get possession over land which may not be their own.
You are already in possession.
Acha. Garb of the aforesaid application, the petitioners are seeking to acquire possession over additional land. Full stop. Be that as it may, once the owners of private patta land makes an application for demarcation of their land before the competent authority, it would be the bounden duty of the authority to deal with that application and dispose of the same by issuing a reasoned order. The said process has not yet been completed admittedly not yet been completed in the present proceeding. In view of the above, without expressing any opinion on the merits of the claims and counterclaims as recorded above, this writ petition is hereby disposed of with a direction upon the respondent number 3 to consider the application for demarcation submitted by the petitioners and on proper verification of records, pass appropriate order therein as may be permissible under the relevant provisions of Assam Land and Revenue Regulation. Needless to say, full stop there. Before doing so, needless to say, since the private respondents have not been heard before disposing the writ petition, the respondent number 3 shall give an opportunity of hearing to the private respondents before passing any effective order on the application for demarcation made by the petitioners.
Dear my lord, private respondent approves the my lord authority and authority pass an order of status quo in respect of the position of the land.
The above action be carried out and completed as expeditiously as possible, but not later than 3 months from the date of receipt of a certified copy of this order.
Obliged.
Writ petitions can be disposed of. Yes.
May I please, your lordship? The petitioners before your lordships are the owners of 3 plots of land which they purchased in 2007 and 2008, my lord, after obtaining NOC from GMDA and also after payment of stamp duty, the sale deeds were also registered, my lord. Now, we initiated the process of mutation in 2011, my lord, and it was rejected on the premise that there was a writ petition which was pending here, my lord, pertaining to retainable areas of the of Ma Kamakhya's deity, my lord. So that case was pending since 2003 and it got disposed of in October 22, your lordship. Now, my lord, in that case, at page 187, your lordship will find the directions which were given.
So you are aggrieved by the fact that your application for mutation
Yes.
has not been acted upon.
Yes, even the process has not been initiated.
But are they joint owners?
There are
Petitioners 1, 2, and 3 are they joint
1,
owners?
2 are joint owners in respect of 1 plot, and the second and the third plot is owned by a company which is represented by petitioner number 2, and petitioner number 3 is the company, your lordship.
So the only order that can be passed in this case,
Yes.
not today,
Yes.
is to consider your grievance, nothing else.
Yes.
You
let-
join,
let
this is a
notice
case
be
of
issued.
misjoinder of parties straight away.
Let notice be issued, let them take a stand on affidavit at least, because there's a clear direction.
Mr. F. Upan, learned counsel for the petitioner. The writ petitioner's hearing claim to be in possession of private patta land, aggrieved by inaction on the part of the respondents in their failure to consider the application made by the petitioners for mutation in respect of the land owned by them. The instant writ petition has been filed seeking a writ of mandamus. Ms. S. Sharma, learned government advocate, Assam, raised for some time to obtain instruction and file affidavit. In view of the above, NOM, when?
My lord, 4th.
Have you booked your ticket?
No, my lord, I have
And-
not. My lord,
You know, nowadays we give dates as per ticket booking.
I'm deeply obliged. My lord, 4th October or 5th
4th
October.
October.
4th October.
4th October will be too soon.
My lord, then any date, your lordship.
Acha, 4th October, all right. Returnable on 4/10/2023. Since Ms. Sharma has appeared in accepted notice on behalf of respondent numbers. Ms. G. Hazarikar, SC Revenue for 1, and Ms. Sharma for 2, 3, and 4. The service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished to the learned department counsel. The respondent numbers 2, 3, and 4 are directed to bring their stand on record by filing affidavit on or before the returnable date. Yes.
Deeply obliged.
May please your lordship. My lord, impugn order dated 9/8/23, page 34 lordships.
Yes.
That is first sentence lordships, last one. Without any valid permission of any competent authority lordships. Lordship, this I have purchased 2 lessees of land in prior to 2004 lordships. And lordships, after that lordships, I have applied before the 32 Tharapur Gao Panchayat. I belong to 32 Gao Panchayat Lordships, and accordingly, Lordships, this Gao Panchayat has granted the permission, has granted NOC Lordships for construction of G+2 building on my 2 lessees of land. That is page 20 Lordships. Lordships, my name is Hunil Kolita Lordships, and Lordships.
I heard Mr. R. Sharma, Learned Counsel appearing for the, yes, GMD.
Lordship, he has two allegations basically, Lordship. One, Dharapur is not within the authority of GMDA. And second, Lordship, the notice that was issued to him, according to us, it was received by one of his caretaker, Lordship. And he's saying that notice was not received. So these are the basic grounds, Lordship.
Lordship, so why don't you hear him and pass an order before
Then
that? don't-
Lordship will dispose of this matter on that ground only, Lordship. So far as the first ground is concerned, Lordship, that is not a reason, Lordship, because from 2009, Dharapur is under Guwahati Municipal GMDA, Lordship.
Lordships,
Heard Mr. R. Sharma, Learned Counsel appearing for the writ petitioner, assigning the order dated 9/8/2023, bracket annexure 7, issued by the Chief Executive Officer, GMDA, Bhangagar, Guwahati, directing the petitioner to show cause, failing which the building constructed by him would be liable to be demolished. The instant writ petition has been filed on the twin grounds. Firstly, that the impugned order is without jurisdiction, since Dharapur does not come within the
GMD
limits of GMD, within the limits of the GMD authorities. Secondly, the impugned order was issued without proper service of notice upon the petitioner. First up, Mr. P. Nayak, Learned Standing Counsel, GMDA, has refuted the contentions of the petitioner's counsel and submits that GMDA submits that Dharapur has now been included.
Since 2009, Lordship.
Dharapur has been included in the year 2009 within the greater
Guwahati Master Plan, Lordship.
within the Guwahati Master Plan, and notice was received by an employee of the petitioner. Full stop. However,
It is mentioned as caretaker, Lordship.
okay,
in the-
caretaker of the petitioner's premises. However, having regard to the nature of controversy involved in this proceeding, I am of the view that the respondent authority should hear the petitioner on his grievance and pass a reasoned order and pass a fresh order before taking any coercive action in the matter. First of Learned Counsel for both the sides have also agreed to the said recourse. In view of the above, this writ petition stands disposed of at the stage of motion hearing by granting 2 weeks' time to the petitioner to submit his reply in response to the allegation, in response to this show cause notice.
Lordship, that show cause to this I have not received, Lordship.
Acha. Disposed of by providing that a fresh show cause notice shall be issued to the petitioner within 10 days from today,
Lordship.
by giving him further 10 days time to respond. Thereafter, the respondents may hear the grievance of the petitioner and pass a fresh order in accordance with law. Full stop. Until such time, the aforesaid exercise is carried out and completed, no steps for demolition of the building of the petitioner shall be initiated.
Till the
Until such time,
Lordship. Lordship, in the meantime, Lordship, petitioner is a normal resident of that premise, Lordship. So we have to serve it to some other person, Lordship, the tenants or.
I am, dear Lordship, I am ready to accept the notice, Lordship, if they are providing. Lordship, Debojit Ghosh, Lordship, he is neither caretaker nor my relative, Lordships. I have mentioned in my writ petition.
all right, so how will they give the notice?
Yes, I am available in my premises, Lordship. They can serve to me, Lordships.
If he is making the statement, Lordship, then it's right.
Mr. Sharma submits that his client is normally residing in the premises and therefore will receive notice if and when the same is served upon him. In view of the above, this matter is being disposed of at the stage of motion hearing with the above directions and observations.
Lordship. Right.
এই করবো আগতে আবার ডিসপোজ করা আছে একটু গ্লাস Yes, Mr. Chaudhary.
May it please. My lord, your lordship may peruse the annexure 2, my lord, that is the order of the deputy commissioner, whereby the entire management of the religious denomination that has been taken over by the deputy commissioner by dissolving the existing committee, my lord, that is elected body. The religious state of affairs, my lord, we have got our right, my lord, under Article 226 of the Constitution of India. My lord, the veracity of the order, your lordship may peruse, my lord.
Order is at page,
At page 57, my lord, annexure 2.
this is an order of July 2023.
Yes, my dear, my lord, a lot of after that order, my lord, the president and the secretary of the religious denomination, my lord, Sri Harimandir Nalbari, a writ petition was filed before the Honorable Court. And at the request of the minister concerned, my lord, who has been made party here, that on 12th of August, a meeting will be held to resolve the matter. And accordingly, that writ petition was withdrawn at the before registration of the writ petition at the by allowing the on getting allowed by
What is
the
the ground on which you are
the
filing?
ground, my lord, is that 26 of the Article 26 of the Constitution of India, my lord, provides the fundamental right to the denomination, my lord. I have referred a decision of Apex Court also that is in reported
Alright,
in.
so we'll get their preliminary instruction. We'll fix it.
My lord,
on them.
now at this stage, my lord, the puja arsana that has been stopped, my lord, that has been gone into the affairs of the deputy commissioner.
No, that's
my lord,
right. This is happening since July 2023. You wait till for another
there are a
one.
lot of development, my lord, already. They
Ex parte interim order, I will not pass. I want them to get
my lord,
response.
it may be taken up after a week, my lord, in
That's
the
what I'm saying.
Deputy Commissioner by name, but.
yes, my lord. It is on Malafide, my lord. I have made a statement, my lord, here in the district commissioner. He has encroached upon the jurisdiction of the denomination, my lord.
But you have not implemented the district commissioner.
District commissioner, my lord, by name, he has been. My lord, I will be allowed to implement the deputy commissioner, district commissioner also, my lord, by and I.
But we would have asked her to obtain instruction from the district commissioner. You have not made him a party.
She has been made party by name, my lord.
No, by name will come later on. That is at the time of final hearing. By name part will be, it will be relevant at the time of final hearing. If there is a element of malafide.
I may be allowed to implement, my lord, the district commissioner also as respondent, my lord.
Mr. Chaudhary, you can do it. We'll give you time.
Yes.
But perhaps it will be better for you to withdraw and file afresh with the pleadings. If you have not implemented the DC, you will not have any pleadings against these.
My lord,
No, you are free to do it. But later on, these things become very big stumbling blocks.
but I have the allegation
And
of.
the courts, legal proceedings.
I have made statement, my lord, regarding the unauthorized action of the deputy commissioner, my lord. How she has taken over the management of the affairs, state of affairs of the religious denomination, my lord.
That is one part.
It has been done on Malafide, my lord.
Oh, you're not even willing to listen. This is one part of the matter. How the deputy commissioner has conducted the thing. But your problem is at the threshold. First of all, you have not implemented the deputy commissioner. Malafide is one angle. But apart from Malafide, it is the authority of the deputy commissioner which is involved
sir.
here. You have not made him a party. So you have to make him a party. You have to file a fresh cost title. Now this is the notification issued by the registry. Until you do that, the writ petition, no order can be passed. That is what I am saying. All these things will take longer time. Perhaps you can
Yes, well,
file it afresh. It is up to you. I have no difficulty. But you have to file an application for implement. That will be allowed. You have to file a fresh cost title. Then only the court will pass an order.
I may be allowed to withdraw the file afresh, my lord.
You want to do it or you want to implement? Up to you. The court has
But
no problem.
Implement is
All right. Heard Mr. D. Chaudhary, learned counsel for the petitioner who submits that the Deputy Commissioner of Nalbari has not been implemented in this proceeding by oversight, although the impugned order has been issued by the said authority. As such, on the request of Mr. Chaudhary, this matter stands passed over for the day so as to enable him to file application for MTT.
Yes.
Item 16.
Ma'am, the petitioner, my lord, is in a difficult situation. The state perception was assessed not only at the state level, but also at the central level. And he was provided with a PSO for a very long time.
This is 4 or 5 bench PSO. Now, after the bifurcation of the bench, these are the teething problems we are having. Perhaps this is a bench 4 matter.
I
No,
have
you
no
will not
idea.
know.
I have not tried to understand that. Huh? I am told that there is a residue which comes to per quote number 5. Huh? No.
Yes. Yes, it is a bench 4 matter.
I don't know. I am at the disposal of
No,
the registry.
that is correct. What happens is this exercise has been done very recently.
I don't
It
know.
has been bifurcated. Now, once or twice, this issue has come up for discussion. Therefore.
Maybe I am told that there is no specific entry there, therefore
No, it
residue.
is subsidiary matters. All.
Item 4.5 also has a residue.
Let it go to the appropriate bench and let it come out tomorrow, my lord, if they have got urgency.
It has got other civil rules also. Is it a bench 4 or bench 5 matter?
Yeah, as per the notification, I think it is bench 5, because bench 5, the last say other cases, other civil rules. Other civil rules, the last caller. Now specifically, this is not, I don't find it in bench 4.
So this is withdrawal of PSO.
PSO.
When was it withdrawn?
Milord, it was actually it was effectively withdrawn on 20th of July 2023. And it has been there for all through, but the central government also issued a weapon of 9 mm, which is normally not given to a civilian. And that has been extended. If your lordships just have a look at page 42 and 43. So it is not one assessment at the state level, but also central government's assessment was there. Therefore, this 9 mm, which is normally not given to civilians, have been given. At page 42, your lordships find the license has been issued for the possession of 9 mm pistol under threat perception basis for self-protection with all India validity subject to state local restriction with 30-50 ammunition as per so and so. And page 43, if your lordship seek, this has been extended. The cartridges are given, and the
So what is the threat perception according to the petition?
You know, the whole problem is he is a businessman. And he has been having activities throughout the major northeastern states, Lord Karbi Anglong, the Nagaland, Arunachal, everywhere.
And at one point of time, he was thought to be kidnapped, which was saved by the police. 2 of his employees are still missing. Investigation is on, but they have not been able to trace. So the threat perception is not only his personnel, which your lordships have held, also Supreme Court has held, that apart from police perception of assessment, it's a matter of self-assessment also. And you can ask for protection from the state on the basis of your own perception. So all this is there. So he has been given suddenly, abruptly, without even telling, without even informing, they are just withdrawn. So that, exposes him to very many difficulties, so it is something which is very personal, in a sense. And also the state has a liability to protect. That's the primary.
No, liability to protect doesn't mean by a PSO.
Your lordships have held that even one can ask, a citizen can ask for a PSO, and if the conditions are satisfied and perception is, threat perception is there, the state has to do it. That's what your lordships have held, the Supreme Court has held, and the state has been giving that on the basis of that kind of.
That's correct, but that will depend on facts of each
Correct,
case.
I have no quarrel with that. So if you do it with this extension till 26 by the central government on a perception of threat, suddenly you withdraw without even notice, nothing. Your lordships have held that you must apply your mind before you withdraw even. After all, some material must be there which must indicate that there is no reason for him to have a perception of threat.
Mr. Majumdar, you are appearing for the state.
My lord,
What is your response?
the petition says that there in 2014 there was a threat perception. Thereafter, the petition is absolutely silent about any incident which gave rise to a threat perception. Petition is silent. There is a representation that is also silent. They are only saying that in 2019, 2 of his employees were kidnapped. So on that basis, my lord, there is no question of providing state PSO. Lord, should you kindly see this representation. He is silent about any present incident, any incident. And my lord, we have got our own SOP. And under the SOP, my lord, the State Security Review Committee reviews the threat perception every 6 months. And thereafter, if there is no threat perception, it is withdrawn. He himself is silent in the entire petition, my lord. Any incident of last 4 or 5 years which gave rise to a threat perception.
This is to prevent incidents. I can't have
and withdrawal
and then come for
withdrawal is
protection.
made on the basis of a
The whole idea
review
is
made by the
different.
SSRC. If the SSRC has made a review and found there is no threat perception, of which he is also silent in the petition, my lord, then there is no question of providing threat
21,
perception.
10, 20.
We'll issue notice, you file your response.
My lord.
Let them file
The
their response.
only thing, my lord, let them produce the records before your lordship, because we have an interim prayer also. So your lordship can have a look at the review done, and whether relevant considerations were there or not, your lordships can see. And that can be done next week, next Monday. Your lordships can ask them to produce
My
the
lord.
record. That's very simple.
My submission will be, in this case, question of production of review, records possibly will not have any relevance, because he is not saying that we have applied before the SSRC or the authority.
No,
SSRC has
file
made some review.
representation.
It is not his case. What the
No,
SSRC,
kindly see, 21, 10, 21, this command is there,
my
which is
submission is,
now withdrawn,
my lord,
page
my-
60.
my
I am
lord.
sorry, you are giving it till now. Suddenly you are abruptly taking it off.
No, the
withdrawal
petitioner
will always be
withdrawn,
sudden.
you have withdrawn it abruptly.
It's not abrupt.
Absolutely.
Withdrawal will always be abrupt.
Correct, but you must,
Based on the report of the SSRC, my lord.
Miller, kindly see
It is,
page
for them it
60.
is abrupt, but then review.
No,
committee,
that is
if
what
they
I
have
am
reviewed-
saying. Let the record
I'll
of the
come up with the
SRCC
instruction
be placed
next
before
Monday,
your lordship.
with
Your lordship
how it was
has to
done.
examine whether they have examined this, all these questions, relevant questions. 21-10-60, kindly see 21-10.
All right, hard Mr. P.K. Goswami, Lord Counsel appearing for the writ petitioner. Petitioner is aggrieved by sudden withdrawal of his personal security officer, PSO, bracket PSO, by the state police. The petitioner contends that there is formidable threat perception on the threat perception pertaining to the writ petitioner. But ignoring such aspects of the matter, the state has withdrawn the security cover, which is posing immense difficulty to the petitioners. First of Mr. D. Majumdar, learned additional AG Assam appearing for the state, on the other hand, submits that the decision to withdraw the PSO is based on proper threat assessment by the Security Review Committee, and therefore he seeks time till next Wednesday. Let it be next Wednesday. You are there next Wednesday.
If your lordships do not mind Monday next week. Again, it is just collecting the record and producing.
28.
Monday.
8/2023 to obtain specific instruction and place the record.
How it was withdrawn.
Register to verify as to whether this matter pertains to civil bench 5 and list this case again for motion on 28/8/2023 as a fixed item.
And interim will be considered on that.
No, it's for motion. There is no need for
But they will provide copy so that she can get.
two extra copies of the writ petition be furnished to Ms. Ajay,
Copy to Ajay
the
DD.
government advocate Assam appearing for the state. Yes.
May it please the lordship. My lord, admittedly, the petitioners are residing on government land since the year 2014 and 1991, my lord. They've got their houses, electricity, city connection, school going children there. Only thing that we submitted our applications under Bosundora portal in the year 2023, page 26, my lord. In the acknowledgement receipt, it is stated, page 26 in the middle portion. If the application has been accepted by the Revenue and Disaster Management Department, the service shall be provided within 300 days. You may raise appeal. Thereafter, appeal for issuance also there.
All right, we'll dispose of, let them submit a representation and be considered before any action is taken. Heard Mr. N.H. Major, we are learned counsel appearing for the petitioners. The petitioners herein claim to be citizens of Assam, citizens of India and permanent residents of Assam. First of, aggrieved by the eviction notices. Which are the eviction notices?
Yes, sir. Page 29.
Eviction notices dated 8/8/2023. Both dated 8/8/2023, bracket annexure 7
Annexure 7. We can access time.
series. The petitioner series directing the petitioner to vacate the land under their occupation. The petitioners have approached this court inter alia contending that they are admittedly in possession of government land, but the petitioners are landless persons and they are also entitled to settlement of land under the project Vasundhara. Mr. N.H. Mazhar Bhuiya submits that both the petitioners have submitted their applications for settlement of land under project Vasundhara, which is pending consideration before the authorities. During the pendency of their applications, if the petitioners are evicted from the land under their occupation, then not only the petitioners, but their family members would suffer immense hardship. Under the circumstances, the petitioners have approached this court seeking protection of this court. Full stop. Ms. G. Hazarika, learned Standing Council, Revenue Department, Assam, and Ms. S. Sharma, learned Government Advocate, Assam, appearing for respond numbers 2 and 3, Aga to 1 and 2 and 3, have submitted that if the petitioners are encroachers of government land they will be liable to be vacated, they will be liable to be evicted. However, according to the Landed Department Council, no action in contravention of the requirement of law will be taken for eviction of the petitioners. Full stop. Be that as it may, since it is not in dispute that both the petitioners have submitted applications for settlement of land under project within courts Vasundhara, which are pending disposal before this court. And considering the fact that they claim to be residing over the plot of government land since the year
1991 and 2014.
Since the year 1991/2014, this court is of the opinion that the grievance of the petitioners should be heard by the concerned authority before the eviction notices are given effect to. In view of the above, without commenting on the rights asserted by the petitioners in the writ petition, the present petition stands disposed of by permitting 2 weeks' time to the petitioners to submit appropriate representation before the Deputy Commissioner Kamrup Metro, that is the respondent number 2, seeking redressal of their grievance. If such application is filed within 2 weeks from today, if such application is filed individually within 2 weeks from today by enclosing a certified copy of this order, the same be examined on merit and be disposed of by a reasoned order before any further action is taken in terms of the eviction notices dated 8/8/2023. With the above observation, the writ petition stands displayed.
Obliged.
Correction.
For motion pending item 5.
The matter pertaining to non-payment of ex gratia relief. My husband died in a road traffic accident.
I had heard Mr. R. Dekal, counsel for the petitioner. The matter pertains to grievance expressed on account of non-payment of ex gratia compensation due to the accidental death of the husband of the petitioner on 5/10/2019. Ms. N. Bordole, Learned Standing Council, Revenue Department, Assam, and Ms. M. Burman, Learned Government Advocate, Assam, have both prayed for some time to obtain instruction in the matter. NOM 6 weeks. Since Ms. Bordole has accepted notice for respondent number 1. Mr. P. Nayak, Learned SC Finance for respondent number 2, and Ms. M. Burman, Learned G. Assam for respondent numbers 3, 4, and 5. Service of notice is deemed to be complete in this case. Extra copy of the writ petition be furnished to the Learned Departmental Council, requisiting numbers so as to enable them to obtain instruction facilitating expeditious disposal of the writ petition. It is made clear that pendency of this writ petition shall not be a bar for the authorities to redress the grievance of the petitioner in accordance with law, if so advised.
Order impeachment of parties. Item 17.
May I please, your lordship? This for the party to make Akashdeep IAS as contempt number 2.
You want whose implement?
Anurag Goyal was previously, he has been transferred. Now Akashdeep BTC as principal secretary.
But where is his name in the, you have not implicated him as an opposite party.
Yes, we did.
His OP number?
In this case, what happened, madam? The earlier Anurag Goyal, he has been transferred from the.
I know, but the person you want to bring in, you have not made him a party in the IA.
He has not been inflated, madam, till today.
Then I cannot take up this matter. We have to try it somewhere else. The person you are seeking to implead,
Yes,
will you not have to make him a party in the IA?
that is nothing. We have not made the party that just because of that was not being implemented. That's why, my lord.
If he is not required, and if that is your stand, then you tell me, I'll accept it. But you can't say he is required, but we have not made him a party. That's not going to work out.
That's true.
Mr. Sharma, if a party is sought to be implemented by an IA,
Lordship.
is he or she not required to be made a party in the IA?
Yes, Lordship. As because that person is to be implemented, he must be there in the IA.
But that case has been disposed of by lord that I.
You withdraw and file afresh. On the prayer of Miss
Elders.
and thus counsel for the applicant, his IA is permitted to be withdrawn with liberty to file afresh after curing the defect in error of parties. IA stands disposed of. Yes.
On next.
18 to 21.
18 to 21, same,
Same.
same.
They're all same orders.
Item 22.
Right,
Yes.
Mr. Lordship. Here we have challenged the impugned order, my lord, 15/11/2021 at page 34. And also challenge the section 7 of the notification 2012, my lord. My lord, page 34,
Who is for the respondents here?
government. Government is. Yes. Here we have challenged, my lord, the order dated 15/11/2021, my lord, passed by the chairman, this DLSA Gopradar, my lord. And rejected the petition, my lord, on the ground virus of section 7 of notification 2012, my lord. Stating that, my lord,
Who
the
is for the respondents here?
government.
Anything you have to say, or should we allow the petition? I'm allowing the petition then. On the ground that state is not opposing.
What do you think?
Yes.
This is ingrained, well, in my humble submission, this is ingrained in the VCS. This
Sorry?
provision, the 6 month thing. One thing that is an aspect that may require lordship's consideration. And also, my lord, the department has written to the senior government advocate. It was received it just now. They are requiring, they are asking for some time.
How much time?
But
Mr.
For 6 weeks.
M. Hussain, Learned Counsel appearing for the petitioner, the learned government advocate Assam. As Sharma has prayed for and is granted 4 weeks further time to obtain instruction responding to the allegations made in the petition.
I'd like.
In view of the above, let us see, let them get.
Yes, ma'am. It may be
Please
given, my
start with
lord.
4 weeks, eh?
My lord, if possible, date may be given.
Date 11 December 2023. List again on.
Sorry, my lord.
Yes. Date, that is a date. Is it not a date?
Date.
There is no urgency in your case. 11 December.
Item
My lord,
22.
after 4 weeks, my lord.
No,
Publish.
after 4 weeks. 11 December.
In this case, my lord, the respondents are yet to file the affidavit, my lord.
Hmm?
My case is, my lord, my mother was a scheduled tribe candidate, my lord. My lord, in fact, she got married to a Muslim person, my lord, and in fact, before my birth, he deserted my mother. My lord, thereafter, my lord, I was brought up by my mother, my lord, and in fact, Subsequently, my lord, I applied for a caste certificate in my name. My mother has a caste certificate, my lord, but that was in fact not issued. On 2 occasions, my lord, I have come before this court, my lord. There were orders, my lord. It was ultimately still not considered, my lord. That is basically my case.
Who is appearing for the state?
I am appearing for respondent 3 and 4, my lord. Up to the year 2018, my lord, all Assam tribal Sangha, they issued the certificate. By virtue of order dated 25th of July 2018, passed in WBC 4840 2018, my lord, they have been restrained to issue caste certificate. Now the deputy commissioner is the only authority, my lord. He can apply for a fresh application, my lord. Deputy commissioner will decide, my lord.
In fact, my lord, Annexure 6 at page 30, my lord. My application already pending, my lord, pursuant to the orders of this court, my lord. This 30.
Where is 16 to 2022?
This page 37, Annex 9. It is addressed to all Assam tribal Sangha.
Page 37.
Yes, sir.
The All Assam Tribal Sangha does not have the
No, my lord.
authority.
Now-
Why is that? Why is that?
My
What
lord,
is the order judgment dated 25/7/2018?
yes, my lord, I don't have the copy, but I can produce it, my lord. There is a restraining order of this.
Take off, take off.
No, my lord. I just came to know today, Mr.
All right. Then you examine it, we'll take it up.
Lordship.
It is submitted at the bar that the all, in view of the judgment dated 25/7/2018, passed by this court in WPC number 4840/2018, the All Assam Tribal Sangha no longer has the authority to issue caste certificate in respect of scheduled tribe category candidates. Now, the jurisdiction lies with the deputy commissioner of the district. However, Mr. R. De Learned Counsel for the writ petitioner, Mr. P. Hazarika Learned Counsel for respondent numbers 2 and 3, and Ms. S. Sharma Learned Government Advocate Assam have sought posting of this matter again after 2 weeks so as to enable them to produce the relevant court orders in this regard in support of the above contention. Prayer allowed, list accordingly.
In other words, my lord, there is a representation which is pending before the DC also, my lord. That page 30 and
No, that's not the point.
Lord,
Does the DC have the power to do it?
Yes, my lord.
Yes, my lord. That is
Why?
what is that is what it says, my lord, that in view of the
No,
judgment.
but you are not aware.
Yes, my lord. I'll go through.
Ablain.
May it please your lordship, on the last occasion, they were asked to file an affidavit in
It's been filed in, it will be filed in the course of the day.
On behalf of
But the respondent.
Mr. V. Pushilal, Learned Counsel for the petitioner. Ms. S. Sharma, Learned Government Advocate Assam submits that affidavit on behalf of the respondent numbers 2 and 3 is ready and shall be brought on record during the course of this week. Ms. G. Hazarika, learned expert revenue is present on behalf of the.
We may be allowed to file our reply in 3 weeks time.
In view of the stand taken by Ms. Sharma and GSM, let this matter be listed again after 3 weeks by tagging the affidavit, if any, filed by the parties in this case. In the meantime, the parties to exchange pleadings.
Interim orders may continue.
Interim order passed earlier to country. Check it once. Check it out. I have 10 lordships. But in this case, on 31/3/2023 lordship, Commander took time for opening instruction lordship. Lordship, matter relating to the lordship settlement of land lordship.
Lordship, I am praying for some time, Lordship. We have not received that.
They heard Mr. B. Malakar, learned counsel appearing for the petitioner, also heard Mr. H. Sharma, learned additional senior government advocate Assam appearing for the official respondents who prays for further 4 weeks time to obtain instruction. Prayer allowed, let the matter be listed.
Item 31.
Yes, who is appearing?
Let's say the petitioner has expired on 3rd of June 2023.
Substitution has to be filed.
I am for the respondent.
Yes, sir. So we need 2 weeks time, Your Honor.
What is the relief paid for?
They have challenged, petitioner has challenged the resolution passed in the AGM lordship. So right to sue does not survive.
That this petition cannot be continued by the legal heirs of petitioner. Mr. Dasgupta, there nothing, this petition does not survive. Right to sue does not.
As he died below, this petition not survive. Some time may kindly be allowed, 2 or 3 days time. I will have to jail.
I am having the death certificate.
Huh?
I am having the.
No, I know, but he is my client. I know he died.
Okay.
But what is he? He died.
It is submitted at the bar that the petitioner had, in this case, had died on 3/6/2023. However, whether.
No, I can produce the death certificate.
No, he died. That's all right. No, but what I'm saying is, either today or on Monday or Wednesday, we close the writ petition because right to sue does not survive. What instruction you want to take? He's challenging a resolution passed in a cooperative society.
Yes.
That resolution cannot be challenged. The proceeding cannot be continued by his legal heirs.
No, legally it cannot be substituted.
Then what remains? It is abated. Any aggrieved person will be.
That is why.
So close it. What is there in it?
Some agree, I will discuss with the associates of this person below, that if they prefer to file an application.
No, will not allow it. Tell them. It is not permissible. It is not permissible because this is not in the personal, if a right to sue survives in personal capacity, then it is a different thing. For example, there is a right on property, the legal heirs come in, their right continues. After his death, this right does not devolve on any other member.
If any aggrieved person, lordship, he can file a fresh writ petition.
Why don't you ask them, we can close it after half an hour, 45 minutes.
Or let the better come there for tomorrow.
Well, but these are needless listings. You see, another good necessary case could have been. Your client is challenging a resolution adopted in a meeting of the cooperative society. He is doing it because he was a shareholder.
My client SL an order passed by the Register of Cooperative Society.
Right.
Whereby the board of director was dissolved and a fresh elections were scheduled to be held. At that stage, your lordship passed.
So he was a one of the board of directors.
No, he is the secretary,
He is the,
secretary of the cooperative society.
right. After his death, his wife will not become. the
No,
secretary.
his wife or his children will not come.
This matter, there is nothing that survives in this matter.
All right, go quickly. Okay, all right, maybe pass.
What will you do by keeping it?
Because I
confidential?
don't have the instruction with these people yet. So
No,
associate
no,
of those
this is not
persons.
as per your instruction. If he has died, I'll pass the order that this being the challenge, no cause of, no right to sue survives to the legal heirs of the,
No, legal, yes, no.
then others can't be implicated. There is no such. Take down, heard Mr. Dasgupta and senior counsel assisted by Mr.
PK Kolita.
P.K. Kolechar and counsel appearing for the petitioner. Also heard Mr. S.P. Royal and counsel. appearing-
Respondent number 6.
Respondent
No,
number
I'm
six.
producing death certificate.
Yes. Who else is there?
I'm appearing for corporation department.
Miss,
Miss S. Bora. My lord, may I record my senior's name.
what is?
MD Bora.
Ms. M.D. Bora, Understanding Council Corporation Department, Assam, is present on behalf of the official respondents, first up. In
Respondent number
this
1
writ
to 5.
petition, the order passed by the Register of Cooperative Societies dated 4/8/2022, dissolving the board of directors by declaring their election as illegal has been put under challenge. First up, the writ petitioner was one of the members of the board of directors.
No,
Then
he's the secretary of the
the
cooperative.
writ petitioner was the secretary of the
The cooperative
society
society.
in question. However, during the pendency of this writ petition, the petitioner has expired. Mr. Dasgupta has produced the death certificate dated 27/6/2023, which goes to show that the petitioner had expired on 03/06/2023. Having regard to the nature of the proceeding and the relief paid for, it is therefore apparent that no right to sue survives with the legal heirs of the petitioner in the present proceeding. As such, on the death of the sole petitioner, this proceeding is abated. The same is accordingly closed. Needless to say, it would be open for needless to mention hearing that regardless of the closure of this petition, it will be open for any affected party to assail the impugned order by instituting appropriate proceeding in accordance with law, if so advised.
This much. Much.
And what is the other IA? What is the IA?
It is their case, Lord.
IA was 3168/2022.
What is the IA about?
That also become infectious.
IA has become infectious. There are two IAs,
Yes, ma'am.
3168 and 3170. These are also closed.
My lord, first may I record my.
Yes, it has been. It has been recorded in bold letters.
I'm the
You want it to be even bigger?
Every person I was advised.
My lords. Also, in this case, respondents have filed their affidavit. I want to file a reply also.
Which respondent is filed?
Both the respondent number 1 is filed
I'm for respondent
1
number
week back.
Mr. S.K. Das, counsel.
My- My lords, it's predominantly a contractual dispute. There's an arbitration clause. Even if they want to file a reply, it won't address the issue.
How do you know that?
My lords, the case of the respondent is to seek
No,
recovery
you
of.
file a counter affidavit.
I already have.
What are you saying? They should not be given time to file.
No, my lords, what they're saying is, in the previous days, it's been recorded by way of the orders also, they only want to file additional information with respect to the candidates. That was what the submission was to the
So
bar.
they should not be given time to file that.
No,
That
my lords,
is-
I'm not saying that. I'm just saying that as per their own submission on the previous dates, and this is not the first time they're making such a request. It's been made almost 3 to 4 times now.
Also, we made a submission before the honorable court that we want to file a reply to the affidavit in opposition. And the affidavit opposition is containing of 500 pages. Lordship.
That has been the consistent submission for the last
And
3
Lordship,
days.
the respondent number 1 has also filed an affidavit on 16. Just
No,
60
but
pages.
you are for whom?
For respondent number 2, my lords, the Assam Skill Development Mission.
So what is your stand? Why?
I stand, my lords, what has happened was there was an earlier writ petition which was filed. The writ petition was disposed of in their favor. ASDM was directed to reconsider the entire case material after their representation is filed. Once they filed the entire, I mean, they are training partners to the ASDM. So the candidate records, which was basically filed, there was a determination which was made on the basis that the verification has failed. Now, this is predominantly a contractual dispute where they have, I mean, what they are saying is that the entire documents on record are originals and the verification data is valid. We are disputing. My lords, they want to come now before before your lordships in a writ petition where there is a contract which essentially has an arbitration clause as well. So the dispute, if any, my lords, is a contractual dispute.
That is
Cannot
your
be taken-
submission.
Yes, my lords.
So we'll hear it today. He wants to file a rejoinder to
My
your
lords,
affidavit. What is the point in, you can say you want it on an early date.
My lords.
Rest
No,
of it was totally
what I was submitting before your lordships was that this request of theirs has been consistently being made for the past 3 to 4 hearings, my lords.
All right, no more time.
My lords.
How much time you want?
4 weeks, Lordship. The respondent number 1 has also filed an affidavit.
Will fix it, your outstation counsel?
No, my lords, I'm pretty much.
You're here. Okay. Mr. S.K. Das, learned counsel for the petitioner, once again makes a request seeking 4 weeks time to file rejoinder in response to the counter affidavit filed by the respondent number 2. Full stop. This court has been apprised that even the respondent number 1 in this case has filed counter affidavit. Mr.
K. Khanna, my lords.
K. Khanna, learned counsel for the
Respondent number 2.
has however submitted that the each petition seeks to raise a contractual disputes which can be referred to an arbitrator in terms of the arbitration agreement, and therefore there is nothing to consider the issues raised, and therefore the issues raised in the writ petition on merits does not deserve full length consideration by this court. Be that as it may, since the petitioner's counsel is seeking some more time to file rejoinder, prayer is granted as last chance. On the request of learned counsel for both the sides, this writ petition is directed to be listed again on 25th of September 2023 as a fixed item. Rejoinder affidavit, if any, shall be positively filed by the petitioner on or before 20th of September, 20 September, by serving advance copy upon the respondent's counsel.
Grateful.
Item 33.
Yes, non-appears for the petitioner. Let us stands pastor of adjourn for 4 weeks. 4 weeks. Mr. H. Sharma, learned additional senior government advocate Assam is present on behalf of the official response.
Item 34 to 40.
But the issue here is covered by the decision of the apex court. The issue is that, while conversion of the raw petroleum coke into calcium petroleum coke, the local taxes which was paid on the purchase of raw material coke, as per section 15B, it was refundable. Now, there was a dispute earlier whether it is refundable or not. The matter was set at rest by the division bench of this honorable court. Thereafter, the matter went to the apex court and the SLP was also dismissed, appeal was dismissed. Thereafter, again, my lord, the department refused the refund on the ground of that there was some larger bench decision of the apex court which the law had been different. Again, the matter went to the division bench and the division bench decided that no, the earlier law which was there, that will be applicable in the case of the items. The matter was carried to the apex court. The apex court also again decided the issue that the refund will be applicable. Now, in my case, my lord, the assessment's claim was submitted. The assessment was completed, but no refunds were granted. Thereafter, when the decision of the apex court, my lord, was pronounced, that to give effect to that judgment, order was passed for refund of the amount. The Commission of Taxes, Joint Commission of Taxes informed me that you agree to a 10% interest undertaking, give it for refund of the amount. I gave the undertaking also. Thereafter, the Commission of Taxes, my lord, by taking an opinion of the legal membership, forwarded the claim of mine to the government that yes, determining the amount that this is the amount refundable and the amount should be refunded. Now we were waiting for the refund. In the meantime, the next Commission of Taxes, without taking note of the earlier order of the Commission of Taxes, he passed a fresh order. And the ground which has been taken in that order is that we were not party in the case of the Supreme Court, one. Secondly, we were waiting for the decision of the apex court backbenchers, my lord. And thirdly, that the order which was passed by the refund was illegal. Now, my lord, there is no power under the VAT Act for review of the order. The Commission of Taxes has passed the order. There is no power conferred on the Commission of Taxes to review the order. Secondly, my lord, it is settled law by the apex court that it is not necessary that one should be party 141 order will be applicable to all. Thirdly, my lord, the order which was passed was to give effect to the order passed by the Supreme Court. So all the three grounds, my lord, for rejection of my claim are not tenable because the Commission of Taxes has passed, if your lordship looks into the Commission of Taxes has passed a detailed order, earlier order, my lord, by quoting the opinion of the legal member, sir, that yes, they will be entitled refund and forwarding the claim of mine to the government for refund. Now, how the new commissioner on the same issue can reject the claim if your lordship looks into the order of the earlier commissioner?
Here, my lord, so far as the cases are concerned, my lord, we have filed an affidavit. The rejection order is there, my lord. I pray the lordship will take up on hearing the either on 31st of this month or 12th, my lord. Some accommodation to them.
My lord, my lord, subject
Either
to this,
31st or 12th, my lord.
this matter was, my lord, earlier also the number of times the matter was taken up. Then the matter was taken up, the view was that no, it is going to be dismissed. Then again, they took time. Again, the matter comes up before.
Either 31st or my lord, 12th, my lord. 12th of September.
No, the only point is, he's saying that the matters be taken up on 31st. What do you have to say on that?
Yes, you also may take up 31st.
31st, you are available?
I am available, my lord. For this case, I will be available. Because it's very difficult to, my lord, now. It goes on, my lord, that because nowadays you're also taking up the old matters. So once the matter comes up, then again goes.
No, fixed date I am praying on 31st.
31st.
No, you are saying that the matter may not reach, is it?
Will not reach. It will not come, my lord, unless and until you passes the order.
No, we'll pass an order.
Yes, yes, on 31st, my lord.
Dr. A.K. Saraf Lanet, Senior Counsel, assisted by Mr. N.N. Datta, has appeared for the writ petitioners in all this, in this batch of writ petitions and submits that the core controversy raised in this writ petition is squarely covered by earlier decisions of the division bench of this court as well as the Supreme Court of India. Full stop. Notwithstanding the same, and despite this specific order passed by the Commissioner of Taxes granting the refund claim, recommending the claim for refund made by the petitioners, along with interest calculated at the rate of 10% per annum. The impugn orders have been issued in flagrant completely ignoring the aforesaid developments, including the favorable report, favorable opinion of the legal remembrancer. First of, Mr. B. Gogoi, Learned Standing Council, Finance Department, Assam, submits that counter affidavit on behalf of the department has been filed in these cases, and therefore these matters be taken up for final disposal at the stage of admission hearing on 31st of August. When do you want? What is suitable for you? 31st of August 2023 as fixed items. In view of the specific request made by the Learned Standing Council, Tax Department, Assam, appearing for the respondents, the registry is directed to list these cases as fixed items on 31/8/2023 for admission here.
Not only LR, they have taken the opinion of Advocate General also. He has also said that yes, refund is to be granted. That has also been ignored.
Would you ask a junior to make a short draft of what are the issues? And you can also present from your side. A very short, not more than 1.5 page.
Some summary only, below.
Just the summary. So that whichever way, whatever order is passed, I will rely on that. Number of petitions there. So
I am obliged. No?
My lord, Instruction from respondent number.
As per the direction of the
Uh,
court, we have filed the affidavit, my lord. The status, my lord.
You have filed affidavit, when?
My lord,
Data Portion has not yet filed affidavit, my lord. The
Affidavit is not on record.
filed on 21/6, my lord. Sorry, filed on 31/7, my lord.
Oh, that is there, yes. So no rejoinder is required.
Yes, only one point is there.
No, rejoinder required or not. If I take up the matter for disposal, I will not join time for rejoinder.
My lord, affidavit from chief executive
Mr.
officer is required.
Counsel for the petitioner submits that a copy of the counter affidavit filed by the departmental authorities has been served upon him, and therefore he will be granted 2 weeks time to obtain instruction and file rejoinder at so advice. In view of the above, let this matter be listed again after 2 weeks as a fixed item. Mr. S. Daftar, Learned Standing Council, PNRD Assam is present on behalf of the department.
My lord,
You say you don't want to file affidavit.
no,
I'll
no,
take it.
I will file.
Otherwise, you will file. What is there to hear in between?
My lord, respondent number 3, affidavit from respondent is required.
In the meantime, affidavit on behalf of respondent number 3, we also brought on record responding to the allegations made by the petitioner.
All right.
Obliged.
Date.
2 weeks, 2 weeks.
May I please, Lordship? I pray for filing the affidavit, Lordship. 2 weeks time, Lordship, to file affidavit in opposition.
Mr. D. Chaudhary, Learned Counsel is present for the petitioner on the request of Mr. K. Sharma.
Yes,
K. D. Sharma, Learned Counsel for the respondent numbers.
FDC, Lordship.
Learned Standing Council, AFDC, this matter stands adjourned for 3 weeks so as to enable him to file counter affidavit.
Item 43.
May I please, Lord? In this case, my lord, the petitioner claims the expiration benefit, my lord, from the respondent of the duty dates of the husband of the petitioner, my lord. The FIR case 13, my lord. The similar situated person also, my lord.
Let it be verified and disposed of launch by the commissioner, by the deputy commissioner. Within a stipulated.
Representation report is not an expert.
Yes,
Sorry?
after verification of the document, that is why I am.
All right. I heard Mr. W. Rahman, Learned Counsel appearing for the writ petitioner. Also heard Ms. G. Hazarika, Learned SC Revenue Department, Assam, appearing for the respondent number 1. And Mr. H. Sharma, Learned Additional Senior Government Advocate, Assam, appearing for the respondent numbers 3 to 6. Mr. P. Nayak, Learned SC Finance, has appeared for respondent number 2. The husband of the writ petitioner, namely late Akan Kalita, sustained grievous injuries in a road accident which took place on the Thoparguri main road under the Hajo police station in the district of Kamrup rural on 04/10/2021. Full stop. Akan Kalita succumbed to his injuries on 5/10/2021 while receiving treatment in the hospital. Full stop. Thereafter, an Ejahara is lodged based on which Hajo PS case number 1990/21 was registered under section 279/304 capital A close of the IPC. Full stop. Since the petitioner's husband had died in a road accident which took place in a public place, as per the government notification dated 15/11/2014, the petitioner, being the wife, was entitled to ex gratia relief of an amount of rupees 2 lakhs. Full stop. Accordingly, the petitioner had submitted an application dated 17/11/2022 seeking payment of ex gratia compensation. However, since no action was taken on the said application, the petitioner has approached this court by filing the instant writ petition. Ms. Hazarika submits that the police report is not yet available in this case. First up, Mr. Sharma, learned additional senior government advocate Assam also submits that instructions are still awaited, but he would have no objection if the writ petition is disposed of with a direction upon the jurisdictional deputy commissioner to verify the claim of the petitioner and process the same in accordance with law, if the same is found admissible. First up, the petitioner's counsel has also agreed to such an order. In view of the above, instead of keeping the writ petition pending before this court, pending any further, this court is also of the opinion that the matter calls for expeditious disposal. As such, this writ petition is being disposed of with a direction upon the respondent number 3, that is the Deputy Commissioner, Kamrup Bracket Rural, to examine the claim of the petitioner, and if the same is found to be genuine, necessary steps as may be warranted under the law be initiated without any further delay for disbursement of ex gratia relief to the petitioner. The other official respondents to cooperate in the process for implementation, process initiated for implementation of the court's order. With the above observation, this writ petition stands disposed of. All right.
Within 3 months, my lord.
The aforesaid exercise be carried out and completed as expeditiously as possible, preferably within a period of 3 months from the date of receipt of a certified copy of the order. With the above observation, writ petition stands disposed of.
46 also same.
Huh?
46 also same. My lord, husband of the petitioner.
Husband of 46.
46, I'm appearing.
46 N Bordoloi for revenue. Accident took place in Hado.
In Kamrup Rural, Your Lordship,
In Kamrup Rural. my lord.
in Uzankuri under Hajo Police Station.
So you give the changes, etc. Mr. J. Henry, government advocate, N Bordoloi, so also. And come on, similar order.
Disposed of, Your Lordship.
Dispose of.
This matter, Your Lordship, I filed my counter affidavit.
Who is for the petitioner?
Mohanto.
He is not present. You filed your counter affidavit.
Day before yesterday. Respond number 13. right, respond. For respond number 13, I am appearing.
Okay, none appears for the petitioner on call. Mr. P. Sharma, learned counsel for the respondent number 13 submits that counter affidavit on behalf of his client has already been filed. Mr. A. Sharma, learned additional senior government advocate Assam is present on behalf of the official respondents. Stuff. However, since the petitioner's counsel is absent today, this matter stands adjourned for 2 weeks.
Item 45.
May I please, Your Lordship? My lord, there is an interim order had been passed by this honorable court on 26/6/2023, my lord, extending the time limit up to 31/7/2023 for allowing the petitioner to stay in the government quarter, my lord. My lord, I am want of instruction, my lord, the current position. My lord, may I pray for a week's time to take the updated instruction, my lord? Paragraph 7 is the relevant.
So that's it now. That order has been passed. We'll close the petition. If he has not vacated, he has been thrown up. There is no application for extension.
No, my lord.
He must have vacated. Why don't you call him up and tell us?
My lord, I have tried, my lord, but I cannot contact. Then, my lord, matter may be taken up on Friday, my lord.
See, Mr. Bhuya,
Mal.
this just listing cases again and again,
Yes, yes,
just
no.
because you want,
No, no,
that's not fair.
my lord. I
A
can
lot of
understand.
process goes on in listing of
I
a
can
case.
understand. my lord.
Some other urgent case
Yes,
is not
yes.
listed because
Mal.
of this. So can you please find out, or else we'll close it by granting him.
My lord,
liberty.
my lord can,
All right, heard Mr. A.R. Bhuyan. He must have vacated, otherwise he would have troubled you. He will not keep quiet. He knows he knows that this interim order was till 31/7/2023. So it is almost a month now.
my lord, actually, my lord, I am not in a direct contact with this person. That is.
All right, we'll note it. Mr.
Right.
A.R. Bhuyan, counsel for the petitioner. Also heard Mr. J. Henry Lane, government advocate, assistant appearing for the official respondent. By inviting the attention of this court to the order dated 26/6/2023, Mr. Bhuya submits that the petitioner was permitted to occupy the government quarter till 31/7/2023. But thereafter, what has happened in this case
My lord.
is not to his knowledge, since the petitioner has not contacted him
My lord.
since then. Full stop. Be that as it may, a reading of the order dated 26/6/2023 clearly goes to show that the petitioner was permitted to occupy the government accommodation till 31/7/2023, subject to his giving an undertaking to vacate the quarter on or before the said date. Full stop. There is no application or prayer made on behalf of the petitioner for extension of the period of stay in government quarter. As a matter of fact, the interim order dated 26/6/2023 automatically stood vacated with effect from 31/7/2023 in view of the language used in the said order. Such being the position, this court is of the opinion that there is no live issue that deserves adjudication by this court in the present petition. The petition is accordingly closed. Yes.
My lord, my appeal, my lord, I had been terminated, my lord. And against that termination, there is an appeal pending, my lord. We have prayed for a, my lord, direction for dispose of that appeal.
It is, however, made clear
My
that
lord,
the disposal of this writ petition by the present order
my lord.
shall not in any way preclude the rights and contentions of the petitioner in the appeal preferred by him
My lord,
against the order of termination from
Right.
service,
my lord.
which may be disposed of by the authorities expeditiously, if not already done.
My lord, if a time limit can be given.
Expeditiously.
My lord.
Yes.
Obliged, my lord.
Item 47.
May it please the lord.
May it please the lordship. Before my learned senior starts, we need some time, your lordship, to file a rejoinder. The affidavit has been filed by the respondents, your lordship, in the matter. We need some time.
My lord, so far as I am concerned, my lord, I am appearing for respondent number 5 and 6. My friend is appearing for respondent number 1, 2, 3, and 4. All the pleadings are complete from our side. My lord, it is the petitioner herein is not a person aggrieved. We have raised the issue of maintainability of the writ petition, my lord. He is questioning some infirmities in a tender process. He is a journalist, my lord. So maintainability, lordship
We need to
will
put that in the
keep
reply,
open,
your
my lord.
lordship. That has been raised by my learned friend in the affidavit. That-
Let them file reply, my lord,
Yes.
but not 4 weeks, my lord, short time, my lord. Otherwise, because there is a repercussion of this, my lord. One person who is going to be appointed as an executive director technical of NRL, my lord, his promotion has been halted because of these complaints, my lord. CVC lordships knows, my lord, vigilance things are taken very seriously, my lord. Complaints are made, complaints are acted upon also. I have brought everything in the affidavit. But before outcome of the complaint, he
Mr.
filed a
N.
writ
Sharma,
petition.
Learned Counsel for the petitioner submits that copies of the counter affidavits filed by and on behalf of respondent numbers 1 to 4 and respondent number 5 and 6 have been received by him, and therefore 2 weeks time be granted to file rejoinder affidavit. Mr. H.K. Das, Learned Counsel for the respondent numbers 5 and 6, on the other hand, has expressed urgency in the matter by submitting that the writ petition itself is not maintainable in the facts of the case. Be that as it may, on the request of Mr. Sharma, this writ petition is directed to be listed again on
5th of September, my lord.
5th of September.
Yes, ma'am.
It is a holiday. We may not come to court. If you want to come,
Then 6th of,
6th of
oh, 6th. I'm so sorry, my lord. Then, my lord, 12th, it'll be Tuesday, I think. 12th of September.
12th of September 2023. For admission hearing,
Yes.
rejoinder affidavit, if any, be filed by the petitioners on or before 8th of September 2000.
With an advance copy, my lord.
With advance copy upon the respondents council.
My presence will occur.
Yes, I said, Mr.
Yes,
KK Parasar,
Yes, sir.
learned, CGC has appeared on behalf of respondent numbers 1 to 4.
Highly.
Release for admission, I just put it out.
Next is a lordship. We have just received a copy of the affidavit. A few while back, we have received a copy of the affidavit.
Today,
Today. Yes.
sure. We take down Mr. M.H. Laskar and counsel for the petitioner submit that copy of the affidavit in opposition filed by the respondent has been served.
2 to 4.
Respondent numbers 2 to 4 has been served only this morning, and therefore 2 weeks time be granted to obtain instruction and file rejoinder. First of Mr. KK Parasar, then as CGC is present on behalf of respondent number 1, and Mr. S. Chakravarti.
SK Chakravarti.
SK Chakravarti for respondent numbers 2 to 4, who do not have any objection if the prayer is allowed. Registry to therefore list this matter again after 4 weeks. In the meantime, rejoinder affidavit on behalf of the petitioner, if any, be brought on record by serving advance copy upon the respondents council. Yes.
Obliged.
60, my last order, there was a direction. We have records have come and affidavit is on the verge of filing. And also, my lord, I'll kindly come to the prayer portion, my lord.
No, you first make up your mind. You want.
Well,
time
fine,
for-
my lord, we are filing a short affidavit regarding mental illness, my lord. They are assailing a order of a learned district judge through 226, my lord.
What, which order? Let us see.
My lord, page 9, my lord, there's a prayer portion. One is the order of the DFO, which is at in finality. They went to appeal before the district judge. District judge upheld those, my lord. And my lord, 226 cannot be invoked, my lord, to assail a judge, order of a district judge, my lord.
Which is the order of the district judge?
It's, my lord, it starts at page 34.
Page 34.
34, my lord.
All right. So is there an appellate provision?
They had availed this, my lord. This is an appeal provision, my lord.
No, against district judge's order, no appeal lies.
My lord, since they can come by 482, but because it's a criminal in essence, my lord. But the 226 cannot come, my lord.
Why?
Because, my lord, the 226, my lord, it my limited knowledge, my lord, it has to limited to if the procedures are followed or not, my lord. Not the merit, my lord. They are assailing it on merit. They are assailing the merit.
Then you have to expand your knowledge, limit of your knowledge.
My lord, the Radheshyam's case, my lord, that 226, it doesn't lie, my lord. Against the judicial order, my lord.
All right, you file your affidavit.
I will file the affidavit, my lord.
Let him file the affidavit.
My lord.
Mr. Heard Mr.
D. Gogol, my lord.
No, petitioners, Mr. Shom, is it?
Lordship.
Mr. Shom, learned counsel appearing for the petitioner. Also heard Mr. D. Gogol, learned standing counsel, Forest Department, Assam, who submits that records have been received by him, and therefore weeks time be granted to place on record a short affidavit on behalf of the department questioning the maintainability of the petition. In view of the prayer made by the learned department counsel, this matter is directed to be listed again after 2 weeks. In the meantime, affidavit on behalf of the department
Will be filed positively.
by serving advance copy upon the petitioner's counsel. Any interim order?
Yes, lordship.
Interim order passed earlier to continue.
Oblige, lordship.
For orders, item 49.
The content is let's say page 22, but in the on last occasion, Mr. Ardhar will be appear. He is supposed to file his affidavit.
Lordship,
Order.
we have received our Wakalatnama. We are yet to receive any instruction.
You are
We
for
haven't
whom?
received
You are
any
appearing for
instruction.
whom?
Mr. Ardha,
For respondent 1 to 3.
Ardhar is
oh,
not
sorry,
party.
all the respondents.
All the respondents.
1 to 3.
Who has given you the Wakalatnama? It's a contempt matter.
Yes, Lordship.
2 weeks to file affidavit. Had Mr. H. Chhatri, learned counsel appearing for the petitioner, Also heard Miss
Tushi Sinha.
Tusi Sinha.
Yes.
Please write your name. So and so, who submits that wakalatnama has been received from the respondent numbers 1, 2, 3, 1, 2, and 3, engaging herself and her senior Mr. R. Dhar as counsel to represent the said respondents, and therefore 2 weeks time be granted for filing affidavit. Prayer allowed. List this case again after 3 weeks. In the meantime, stand of the respondents will be brought on record by filing affidavit as to the steps taken for compliance of the court's order. Yes.
Item 15.
Your Lordship, government has filed their affidavit, we have also filed a reply. Let it come up for admission, Your Lordship.
Mr. S. Botakul, learned counsel for the lead petitioner, submits that pleadings have already been exchanged by and between the parties, and the matter is ready for admission hearing. Similar is the stand of Mr. J. Hennig, learned government advocate Assam, appearing for the official respondent. In view of the above, registry to list this matter for admission hearing.
Item 51.
Lordship, the petitioner belongs to the Kavarta caste, scheduled caste, Lordship. And Lordship, my caste certificate has been cancelled without constituting a committee as required in Madhuri Palit case, Lordship.
Madhuri Patil. yes.
Patil case, Lordship. That is reported in.
Mr. Roy, Palit and Patil are two different sides.
Patil, yes, yes. Parik.
Yes,
Parik means Lordship Gujarati generally, and Patil means.
All right, so what is the prayer today? What is that you want?
Prayer Lordship.
They filed their affidavit?
No, they took time for filing, but they have not filed. They took time, my lord, this matter was, Lordship will please to peruse the order dated 23/6/23, by which the interim.
So
prayer-
these cases have to be disposed of. So we allow the petition. You are agreeable? Where is the caste certificate?
Yes, caste certificate, Lordship. I am having original also, Lordship. I have an.
No, where is the annexure in the writ petition?
Yes. Page 18, Lordship.
Who has cancelled this?
This has been cancelled by the ADC Morigaon Lordship, who has no power or jurisdiction, Lordship. Even DC does not have any power as per the 1994 SC decision, Lordship.
And where is the order of cancellation?
Order of cancellation is Lordship in order, page 30. And that too on the complaint lodged by my adverse party against whom I am fighting civil suit.
Without hearing you?
Without hearing.
Give me the Kumari Madhuri Patil judgment.
Yes. So,
Mr. Hendrik, you are for whom?
Lordship, may you please to peruse clause number 13.4. I have highlighted. A high power committee is to be constituted for cancellation.
In the additional affidavit, they have stated that, but at the hearing was second place, my lord, the petitioner was present on that. Before the additional.
No, no.
Paragraph number 4.
No, but anyways, it has to be done by a committee, cancellation or grant of certificate. Not the, not the.
2018, after the 4 years.
Lordship, I have annexed, it was never communicated to me, Lordship. I come to know when my adverse party who lodged the complaint in a civil suit
that my caste certificate. For that, I have filed a additional affidavit explaining why it delayed on my part. Order was passed, it was never communicated. And Lordship is fully aware, an order passed, not communicated, is a nullity in the eye of law. Who is for response number 6?
I'm for respondent.
Yes, what do you have to say? All right, take your seat. Heard Mr. S.P. Roy, learned counsel appearing for the writ petitioner. Also heard Mr. J. Handy, learned government advocate Assam, appearing on behalf of the respondent numbers 1 to 4. Miss, your name, please?
M. Nath.
M. Nath.
M. Nath.
Learned counsel is present on behalf of the respondent number 6. Why you can't appear for the chairman, Scheduled Caste Development Board? 1 to 5. He is also a government functionary. None has appeared for respondent number 5. The writ petitioner herein was holding a certificate, a caste certificate issued by the Subdivisional Scheduled Caste Development Board of Morigao, dated 25/2013, whereby it was notified that he belongs to the Koiborto community, which is a recognized scheduled caste in Assam, agreed by the order dated 29/2018, passed by the respondent number DC Lordship 3, cancelling the caste certificate of the petitioner. The instant writ petition has been filed. Mr. Roy submits that the respondent number 3, being the district magistrate of Morigao, respondent submits that after the decision of the Supreme Court in the case of Kumari Madhuri Patil versus additional commissioner reported in 1994 6 SCC, page 241. 1994 bracket close 6 SCC, page 241, requiring that the a specially constituted scrutiny committee would alone be authorized to examine the validity of a caste certificate and also to cancel it if deemed necessary. Mr. Roy submits that the respondent number 3 did not have any authority or jurisdiction under the law to issue the impugned order, cancelling the caste certificate of the petitioner. First up, it is also the submission of Mr. Roy that the proceedings were initiated at the instance of the petitioner's rival in a civil proceeding, that too without giving him proper opportunity of being heard in the matter. Under the circumstances, the impugned order is bad, both due to want of jurisdiction as well as for violation of principles of natural justice. First up, Mr. Hendik Learned, government advocate Assam, submits that he has not received any instruction in the matter. First up, Ms. Nath, learned counsel for the respondent number 6, has also not advanced any argument in support of the impugned order. Be that as it may, there can be no doubt or dispute about the fact that the decision in the case of Kumari Madhuri Patil, bracket Supra, delineates the procedure that is to be followed in the matter of issuance and of the cancellation of caste certificates. Paragraph 13 lays down certain guidelines which are required to be followed by every state government and its authorities. However, from a perusal of the impugned order dated 29/2018, I am of the view that no such procedure as prescribed by the Honorable Supreme Court has been followed in this case. First of all, moreover, materials available on record also does not indicate that the impugned order was passed after giving proper opportunity of being heard to the writ petitioner, first up. It is no doubt correct that there is some delay in filing the writ petition. However, the assertion of the petitioner that the impugned order was served upon him after much delay, as a result of which, was never served upon him.
Never, sir.
And he came to know about the same only when this said fact was disclosed by his rival party in the civil suit. I am of the view that the petitioner cannot be non-suited only on account of delay in approaching the court, assigning the impugned order. Full stop. For the reasons mentioned herein above, this writ petition succeeds and is hereby allowed. The impugned order dated so and so is accordingly set aside. Consequently, the caste certificate earlier issued to the petitioner on so and so date, the date is there, stands revived. This order would, however, not come in the way of the competent authority initiating a fresh proceeding so as to examine the validity of the caste certificate of the petitioner, if so advised, after following due process of law. Writ petition stands closed.
Obliged.
Fifty-two, your lordship, respondent have filed an affidavit. We will want to file a reply to that, your lordship, 2 weeks time, maybe, right?
Mr. S. Bhattakur, learned counsel for the petitioner, submits that he has received a copy of the affidavit filed by the respondent, and therefore we granted 3 weeks time.
2 weeks.
3 weeks. In between, there are some holidays, 3 weeks time to file rejoinder. Miss
J. Rajkumar, on
J.
behalf of
Rajkumar.
Mr. S. Bora, J. Rajkumar.
Mr. S. Bora, learned counsel is present for the respondent and does not have any objection if the prayer is allowed. The registry to list the case accordingly.
So in this case, earlier notice was issued, lordship. We have taken step, lordship. A particular portion of the order is page 11.
So has notice been served?
Lordship,
Heard Mr. L.R. Majumdar, learned counsel for the petitioner, none is appeared for the respondent. From the office note, it is not clear as to whether notice has been served on the sole respondent in this case. Registry to, therefore, place this matter before the Lojima court for verifying on the above fact. List this case accordingly.
Right.
Item 54.
This is a contempt petition, my lord. The office note 19A found that my respondent 1, 2, and 4 appeared, my lord. But their affidavit has not been filed.
And I do appear for respondent number 2, but however, respondent number 2, my lord, he has been wrongly implicated, my lord. He is the chief engineer PWD. Pawan Terai is the person who is to be implicated as respondent number 2.
You are appearing for whom?
But otherwise, for respondent number 2, my lord.
You are for respondent number 2.
Respondent number 2, Sanjeev Shyam.
And what about you?
We filed for 1 and 4, respondent number 1 and 4.
And what about 3?
Lordship, 3 is in the police custody, Lordship. He's the executive engineer of Dima Hasao Hapla.
Well, what happened that from the source we came to know that he was arrested in corruption
Yes,
case
Lord.
by the anti.
I heard Mr. B. Burwal, learned counsel for the petitioner. Also heard Miss J. Gogoi, learned counsel, appearing for the respondent numbers 1 and 4, who submits that the respondent number 3 is presently in police custody, and therefore
New incumbent has, new incumbent has appointed.
a new incumbent has now been appointed to function as executive engineer, PWD roads in Dima Hasao, Haflong, full stop. Mr.
D. Kolita, my lord.
D. Kolita, learned counsel, has appeared for respondent number 2 and submits that his client has been wrongly implicated in this contempt case. Be that as it may, on the request of the learned counsel for the respondents, 3 weeks time is granted for filing affidavit bringing their stand on record. The petitioner may file rejoinder thereafter if so advised. List this case again after 4 weeks.
Obliged, my lord.
My lord, the respondent she named there to disclose, my lord, the new joining person there. So that
In the meantime, Ms. Gogoi to furnish the name of the new incumbent in the office of Executive Engineer,
Yes.
PWD Road, Haflong.
yes. Obliged.
Item 55.
To the petitioner.
This is also same money,
Same,
same,
parties are same,
same money. Respondents are same money,
same order.
same order.
All right.
Obliged.
56.
Lordship, I 2120, we have filed for rectification of type and translated copy of annex number 4. Lordship. So correct DAG number is 1046. We have wrongly mentioned the DAG number is 40, Lordship. Rectification may be allowed, Lordship.
Application, which page is the order of the court?
Next, sir. And next are 4, Lordship.
Page number?
4 in the read petition, Lordship, page number 21.
You could have given a copy here. Let's see.
Main read to the.
Order dated,
No, order, Lordship.
then
We have
So DAG number in the annex, your lordship. Basically, it is a report from the circle officer to the DC. Can I do it? It is not.
full type.
Oh, wrongly typed.
Wrongly typed, Lordship.
what you have wrongly typed?
A DAG number, Lordship.
Where?
In page 21, Lordship. Annex are 4, Lordship.
So you are saying amendment of writ petition?
No, rectification.
You can't rectify writ petition. like
Yes, sir. Surface.
It should be done. You make a mistake,
No, you are type.
put your pencil like this and something like that you want.
No.
That's not permissible.
Actually, during translation, we have made mistake, Lordship.
Whatever, you have to file amended writ petition.
Okay.
We'll allow him, let him file amended. writ petition. I heard Mr. J. Gogoi, M. J. Gogoi, Learned Counsel appearing for the applicant. Also heard Mr. C.K.S. Borua, Learned Government Advocate Assam appearing.
CC.
Huh?
CC.
Learned CGC appearing for the respondent numbers 1 and 2.
And for
Miss-
3.
Ms. N. Bordole, Learned SC Revenue has appeared for OP number 3. And Mr. J. Hending, Learned G. Assam, Additional Senior Government Advocate Assam for respondent numbers 4, 5 and 6. This IA has been filed by the writ petitioner in WPC number 8426 of 2022 with a prayer to amend the writ petition on the ground that a DAG number of the land has been erroneously quoted in the writ petition. Full stop. According to the applicant, the correct DAG number is
1046.
1046, but it has been erroneously mentioned as
40.
440
Yes,
in paragraph.
In annex are 4, Lordship.
Oh.
Page number 21
Page number 21.
of the writ petition.
So where is the original of this?
Next,
22.
22, Lordship.
There also it is mentioned wrongly.
No.
It is correct. It is correct.
Yes.
While translating, he did the
The
mistake.
type copy is wrong.
Yes.
Wrongly mentioned as DAG number 40 in annexure 4, which is a type copy of the order dated 25/5/2007 issued by the Circle Officer Palasbury Revenue Circle. Full stop. The learned counsel for the opposite parties have not opposed the prayer made in the IA. In view of the above, the prayer made by the applicant stands allowed. The applicant stroke writ petitioner to file an amended writ petition with the correct DAG number being mentioned in annexure 4. By rectifying the defect therein, the amended writ petition be filed within 2 weeks from today. IA stands disposed of.
Copies of the amendment petition will be given to us also. We'll
That is-
place it.
Sure. Obliged, Lordship.
Item 57.
May it please your lordship. Your lordship, the matter was listed before the law Zimmer Court on 11/8, your lordship, and we have been instructed to take fresh steps upon respond number 4 and 5. We had taken steps, your lordship, but there was some miscommunication. That's why today again we are applying for the fresh steps upon respond number 4 and 5.
For response number 3, man. Arunachal. Miss N. Mahanta, counsel for the petitioner submits that although steps were taken as per the order dated 11/8/2023 of the Lower Zimmer Court, yet due to a communication gap, there was an error in the process, as a result of which she seeks leave of the court to take fresh steps for service of notice upon respond numbers 4 and 5 by registered post with AD. First up, Mr. B.D. Goswami, Learned Counsel, is present for the respond number 3, and Mr. J. No, and does not have any objection if the prayer is allowed. In view of the above, the petitioner is granted time till tomorrow to take fresh steps for service of notice upon respond numbers 4 and 5 by registered post with AD. This matter will be listed again after 4 weeks with appropriate official.
Deeply obliged, your lordship.
Is there any part 2 original list? No list.